One of the things I said earlier is that in Sweden there isn't a tradition of, say, the Bar Association as part of its ethics requirements requiring lawyers to work pro bono or work for people who need help, who can't afford to pay for it. That's part of the tradition in the U.S. That doesn't mean that all pro bono work that's done in the U.S. is necessarily meaningful. A lot of it's just public relations, as far as I'm concerned. But it is an interesting idea. And the thing is, it would be unfair for me to say that there aren't lawyers doing good work and who are not necessarily out for every last dollar. There's a lot of legal work being done in Sweden, sometimes for free, sometimes at reduced rates, just because lawyers do want to help, do want to provide assistance, but it's, again, not necessarily part of the tradition. But here we do have two lawyers who are practicing or have been practicing. Stellan Gärde from Applied Human Rights, Mike Rates from, what's the law firm? Minerva Law Firm.
She's the chair of the ICJ Sweden.
Thank you for your help.
Yeah.
She's also the chair, or co-chair, of the International Commission of Jurists in Sweden, and has been the co-chair for 3-4 years now. And so mainly we wanted to hear your reflections of what you heard today, any interesting ideas, what can be done here, and questions for Sid and Pat.
Can I start?
Who should we start?
Mai should start.
Welcome. Of course.
So thank you, and very interesting. I would say it's very inspirational, and I think in general lawyers in Sweden who are interested in or doing work for human rights have been and are still very inspired by the work of our colleagues in the US. Actually, I think it was a year ago that a law student here in Stockholm went to the US. He made a report, Rami Al-Khamisi, about he called it report. It's a good report actually about rörelsejuridik, about movement lawyers in the US. So it's been it is an inspiration, and I think what Paul said also, that it's the beginning of a process, and I think we're learning by doing a bit, and I see there are some obstacles, of course, inherent in the Swedish system, so that, for example, there's a fear of juridification of the system in Sweden, so that there's been a resistance against moving more power to the judiciary, as in contrast to the political powers. So we don't have a tradition in Sweden of the separation of powers, for example. We have traditionally a weak constitution and a strong parliament and government. But the system is also that we have more of a vertical separation of powers. So the government is not allowed to interfere in the authorities' decisions and work. But traditionally there has been resistance against, and even working with the constitution or now the European Convention of Human Rights is law in Sweden, but to use that as an argument in courts you've always been regarded as a little bit crazy, or to use that tool. And that is changing, of course. It's changing. It's a slow pace, but it is changing. And it's also been a tradition in Sweden that we look at the problem. So whenever there's a problem, we investigate a little bit, and not so much. The tradition of lawyering also in Sweden, we don't litigate, we investigate. So, but that also that also has, of course, some impact, and Paul mentioned a human rights organization in Sweden, Civil Rights Defenders, and they have a project now that I was happy that they initiated. From one part of my family has big problems with psychiatric diseases, and what they're looking at now, Civil Rights Defenders, are people in closed institutions, and that has been like a real hidden problem, I think, in Sweden, for instance. One reflection also what Sid said about different methods. I think one obstacle also in Sweden has been when you litigate, it's not a fast process. Sweden has been in the European Court of Human Rights. There has been cases, a lot of cases in Sweden regarding Article 6, that we have too long handlingstider.
Too much time for courts to come to a decision.
Yeah, simple as that. So, but I think that is also an awareness, and it's improving also in Sweden. I mean, from what I see, and I think like what people continue to do also is that, and that's why I mentioned also the report that was quite initially, that was it was well received and highlighted, that there are attempts, and it's a growing movement, I think, of and awareness that this is a possible path also in Sweden to gain more rights through litigation. And I mean, I'm hopeful. Yeah.
And Stellan.
Yes, you know, we in some regard we do have the culture of litigating in Sweden as well. You know, I've been working for trade unions since 35 years, and the trade unions have enough funding to organize their own lawyers' firm. So they have about 30 lawyers who nationally take cases to court. And I think every year they bring about 50 million back to the members and the trade unions regarding compensation or damages or trial costs and everything. So, and I think, and this is not well known in the sense of, because we are saying all the time we are not a litigating country, but we are. The only thing is the focus for the one involved. You know, if the disability movement like to develop a law firm, they can do it. And if they like to litigate, they can do it. The only way is to have the focus, to see the possibility of it. And I would love to organize a meeting with the trade union lawyers and the leaders of the disability movement in Sweden to say how it's done. It's only to pay the cost. It is a cost involved, of course. And the trade unions are not quite wealthy. They were more wealthy before. But normally, I can say the cost for the lawyer's cost normally is quite balanced by the cases that they win. They will take most of the cost of the trade union lawyer's activity. And they take cases to labor court, they take cases to the local court, the appeal court, Supreme Court, to the European Court of Human Rights, to the European Union Court. So they are open for international law, Swedish law, European Convention, everything. We have done it 20 years back, 30 years back. And so the momentum is not that it's difficult to do it. It's just for people's mind to see how that they want to do it. And I think that is the biggest problem, as I might say, that we don't like to judificate. A lot of these organizations on the disability movements in Sweden, they don't normally have lawyers involved in their organization as such. And if they do, it's quite young lawyers who normally don't do so much legal work. And I think now we are starting this, and the problem with the Swedish funding agency for the government, is Arvsfonden, is that they don't like to support legal action. That was the idea with the Adolf's applications and so on. And now we are trying to struggle to find a way forward, to find funds. And if there will be funds, the way forward is, there is not a big problem to go into the system and litigate. We do have the knowledge, and we can do it. And I think lawyers are not, if the disability movement want to litigate, I don't think lawyers will say, no, we're not interested. Absolutely not. But the mandate must not come from the lawyers. The mandate should come, I think, from the organizations. Politically, organizationally, and personally, there is a need to trust among the people.
Do you see any problem with the general attitude toward lawyers, especially from civil society organizations? Because at least what I run into is both political parties, civil society organizations, they usually look at lawyers as being roadblocks. They look at lawyers as not being helpful.
Right.
Lawyers cause problems rather than lawyers provide solutions.
I think the biggest problem is when lawyers come into this kind of open society, civil society. Normally what they do, they have enough knowledge and enough structure to do things. So they normally get at the point of the chair of the organization. In 2-3 years, they will take over the organization and say, because everyone say, oh, he knows things and she knows things, and everyone have a trust, and they go to this shared position. And that is a problem, that they are not looked upon as a service function to the ordinary political structures. So I know in trade unions, very, very much, they have been very much afraid of employing lawyers because they immediately go up to the position of chair. So they will have and that is a fear that I think, so that's why the trade unions organized a separate company where the lawyers' actions were developed. They were not employed normally, but employed by a separate company, a shareholding company, owned by the trade unions together. So they were not involved in the political decision making and onto the congresses and so on. That is, I think, very important, because that should be a mandate between lawyers and the organizations, and the lawyers should not take over it. Absolutely. And I think also what is the problem is that we have a lot of young lawyers who like to take action, like to go for human rights and so on. But I think there is a lack of litigation knowledge among this group, in the sense of that, because I would like Sid to tell me, because if you're going to litigate a case, before you take the decision to say, we take the case to court, and I like to you must tell Adolf as well. Before you take the case to court, you have to have a very structured, good grounded legal analysis for the case as such. To base this is possible to take, this is not possible to take, this will regard a lot of people, this will not regard a lot of people, this is a legal grounds, this is a prospect of success, and so on and so on. So that's and I envy you to have 6 lawyers to sit, or 10 lawyers to sit and discuss. And I heard that you talked about that it's a very interesting discussions among your own staff when you take cases. And I think that is lacking in Sweden, that there are a lot of experienced lawyers who are not in this kind of movement of idea to take law to as a protection of disability rights.
Could you take on that question about, say, the very practical preparation that's needed? You said you won a lot of cases, But if you're going to win, you have to be very prepared.
Well, there are several dimensions to this as I'm listening to this. You know, one part of it is what you described is in fact what we do in every case. That is, we start with the client, and the client is almost, as I've indicated, is almost always, the true client is almost always a disability organization bringing the problems to us. And then we start an entire process in which we factually investigate it. And by the way, this is a terrific use for law students. We use students a lot. We get them at least 4 law students in our California office and 2 in our New York office every summer, and they do a lot of this investigation, fact investigation. Then we look at the state of the law. We probably eliminate about half of the cases on the basis of it's an injustice, but I don't need to tell lawyers there are lots of injustices that just don't have a legal solution to them. All right. And then we also try to look at, in the United States, we call it forum shopping. I don't know what lawyers here call it. Where can we bring the case so we get a good judge? All right. Because I don't need to tell you as lawyers, the good results don't just come from legislation, they come from a sympathetic judge. All right. Where can we get good support from the disability community? This process that I'm describing of selecting the case, developing the case, and we go to the law firms and ask them to do legal research on different issues, often takes a year and a half.
Right.
It's not at all unusual to work up a case.
Also the board,
Huh?
the litigation.
Right, and then Pat reminded me, we have a litigation committee on our board of half a dozen quite prominent and very skilled trial lawyers who often make strategic suggestions to us or telling us we're dreaming or whatever other suggestion that they can make. So it's a very tricky process. I will add one other thing. When you talked about sometimes lawyers are not problem solvers; they're obstructionists. We start from day one thinking, what is the solution to this problem? And we, again, this can often be a year before we even file the lawsuit. And we bring into that process experts. And because we're an NGO, we're lucky enough to often get people who are experts from academia or elsewhere who will volunteer their services to us, and we involve the clients. We say, what do you, this disability group, what do you want to come out of this? What do you want to see happen? What do you think will work for you? It's a tricky process.
And I should say one of the signatures of our law firm is to replicate lawsuits that have been successful. So Sid mentioned the emergency evacuation cases, our hospital access cases we've replicated, transportation cases. So when you have a winner, you have all the research essentially done, and you just have to move on to the next site in the country where there's the same problem. It requires some shifting of things, but it works much better than starting a whole other area of the law.
I can add quickly onto that is one of the ideas with our website is going to be to try and find cases sort of like in the US you can find cases in different states. We can find cases in other parts of Europe. If they're successful, why not bring those cases here so that lawyers at least can be exposed to the thinking and maybe the proof and how the cases were developed. So that's one of the, Stellan.
I'll add one, I'm sorry.
No, okay.
I was going to add, we like to say the case has to appeal to your gut, all right? That is, the case has to be one in which a person will say, who hears about it for the first time, will say, yes, that's an injustice, and we need to do something about it. Okay, I used to use as my secret criteria, in addition to our litigation committee, my grandson. Right? And if he didn't get it and he wasn't in favor of it after 5 minutes of explaining, then there was a problem with it. All right? Yeah. Okay. Now he's gotten too smart. I don't use it.
Stellan, you have to...
Nej, alltså vi har ju... sorry. We do have this kind of rättsnätverk, network legal network, that we have 35 lawyers who has committed themselves to take a pro bono cases. And they are more or less the one who symbolize the future of law firm who do take cases. But now it still is very few of them who have enough time to take cases on regularly because they are occupied. But I think we have the idea. But I'd love to also say that my idea about funding is that I think Sweden is quite a small country, and I think discrimination is something that people would love to get rid of, or at least have an action against. And I think that could be developed quite soon. A lot of organizations could be parts funding different things.
Okay.
And I think it would be the best thing was to have a common fund against discrimination in Sweden, and with separate criteria for different parts of cases. But also to say that I think the fund must be independent of the organizations and of the lawyers, and have a separate, as you say you have. I think we need some group of trustees. We need a litigation committee who will take the decision on specific criteria. But I would love to have your how you have organized the funds, how they are related to your firm, and are your firm your private firm, or is it how is it related to the organization and so on?
We're what you would call an NGO. In the United States, we're a non-profit organization. That is, we don't have ownership like as if you had a private firm. I'm a salaried employee. Pat was a salaried employee. Okay. Our lawyers make much less than they would make in private practice. So we are a not-for-profit. Okay. We essentially exist financially by a combination of all the funding devices that Pat was our fundraiser for almost 17 years. She's retired before me, right? But we now have another full-time fundraiser. So all these funding devices, but the other half, at least, of our is fees. That is attorney's fees when we win the case, paid by the losing party, and we're almost always the winning party. Which brings me to something I want to say specifically because we have lawyers here. And it's something that dawned on me as I've listened in the last couple of days to issues in Sweden, and that is lawyers have an absolutely essential role to play in dealing with procedure and in being creative and helpful to the disability community on what all of us would call procedural issues rather than substantive issues. So when we've encountered a response from the Swedish community of the difficulties of doing something, it's often been, from a litigation point of view, it's often been procedural almost as much as substantive. So, for example, having a class action has been enormously important to the disability community in the United States. Having a fee shifting provision built into the legislation. So what the Americans with Disabilities Act and the Rehabilitation Act, all these acts provide is that the disability community, when it wins, can get its attorney's fees from the losing party, but the losing party cannot get fees against the plaintiff unless the lawsuit is frivolous. That's our rule. All right. A third, and this is the last one, but we heard it yesterday, is the limitation in Sweden. You don't have, as much as we have in the United States, the right of a court to give what we would call purely equitable relief. Okay, forget about damages. The right of a court to say, as the judge said in New York to the city, you must formulate an emergency plan. I'm going to give you 6 months, but you've got to formulate an emergency plan, or I'm going to formulate one for you. All right. All three of these devices are not some 200-year-old thing in the United States from English common law. They were developed by lawyers through legislation. The class action is embodied in the Rule 53 of the U.S. Federal Rules of Procedure. The right to fees was written into the Americans with Disabilities Act in 1992. Equitable relief has developed as part of the legislation. And those of you who are lawyers, you know, this is your role. This is what your training can help you do.
Okay, as a moderator, I get to have the final comments here. One thing that I thought about as you were talking is, say, human rights law. Quite often in Sweden, there's an idea that human rights law is very much based on, say, your gut feelings, right and wrong, but it's not based on doing the nuts and bolts of the legal work that has to be done. It's the nuts and bolts that leads to good legislation. It's also the nuts and bolts that lead to good litigation. And that's why it's important to keep an eye on those kinds of issues. I want to thank the panel today. Again, I can just say thanks.
Great to be here.